Over the years, the sanction strength of the court was increased, and currently it stands at 34 judges. As the number of cases increased, the court started sitting in smaller benches of 2, 3, and 5 judges. The Supreme Court's jurisprudential approach has been evolving. In the 1970s, the court adopted a broad, purposive, and contextual interpretation of the Constitution. In the past few years, the court has furthered the transformative vision of the Constitution by recognizing and protecting fundamental rights such as the right to privacy, decisional autonomy, and sexual and reproductive choices. Our court has emerged as a strong proponent of gender equality, whether it be in its interpretation of the laws of inheritance or securing the entry of women in the armed forces. The court has also ensured that the criminal justice administration is not delinked from the framework of human rights. For instance, while the death penalty has been upheld to be legal and constitutional, the Supreme Court laid down various mitigating and aggravating circumstances that a judge should take into account before awarding the sentence of death. This ensures fairness in the process. Procedural innovations, open court hearings in reviews arising out of death penalty cases, or psychiatric assessment of death row convicts have a humanizing influence on the law. Thus, the court has sought to use the language of the Constitution to humanize law and act as a protector and defender of fundamental rights and liberties. In the past few decades, India's legal landscape has undergone significant changes with the adoption of legislation such as the competition law and the insolvency and bankruptcy code. Consequently, commercial matters now comprise a significant part of the daily docket along with criminal matters. While dealing with such cases, the court has often drawn upon the new and emerging jurisprudence developed in other jurisdictions. To give you just one example, in dealing with the insolvency and bankruptcy matters, the court is often referred to principles enunciated by the Singapore courts because of a similarity in legislation. I did so in my decision in EBIC Singapore Private Limited versus Educom Solutions. In arbitration cases, the court has taken a conscious stand of upholding the sanctity of contracts. The Supreme Court has made a constant endeavor to ensure access to justice for everyone. The court has facilitated increased access to justice by diluting the requirement of local standi through public interest litigation in the 1980s, by which anyone can approach the constitutional courts in India to seek a redressal of a violation of their fundamental rights. By doing so, the court opened its door to persons bereft of the means to approach the court because of their social and economic disadvantage. This has provided a space for citizens to converse with the state on equal terms. In turn, the court has been using its jurisdiction to make the rule of law a daily reality for persons belonging to the marginalized communities. During the COVID-19 pandemic, the Supreme Court adopted innovative technological solutions to reach out to the people by adopting video conferencing of court proceedings. During the period between 23rd March 2020 and 31st October 2022, the Supreme Court alone heard 3.37 lakh cases through video conferencing. We updated our video conferencing infrastructure in courtrooms at a meta scale, and we are continuing to use such technological infrastructure to allow a hybrid mode of court hearings that allows parties to join court proceedings from any part of the world online. In the recent budget, the Government of India has announced a provision of Rs 7,000 crores for Phase 3 of the eCourts project. This will help to enhance the accessibility of judicial institutions and improve the efficiency of the justice delivery system in India. Such endeavors will ensure that the court truly reaches out to every citizen of our country. If we peruse the history of this court, we realize that the history of the Supreme Court is a history of the daily life struggles of the Indian people. The mentioning list every morning in the Court of the Chief Justice of India spans anywhere between 60 to 100 cases. Through these seemingly innocuous requests, we can sense the pulse of the nation. Above all, we send a message in this uniquely citizen-centric initiative, and that message is of an assurance that this court exists to protect our citizens from injustice. Their liberties are as precious to us as to them, and that the judges work in close connect with our communities. In conclusion, then, let me say that there should be three principles which should guide our approach, and I borrow something from what has been delivered by the greats of the past who have decided cases before us. First is that we must apply the precautionary principle in the work which we do. Second, we as judges must apply the principle of sustainable development, because it is the principle of sustainable development which will ensure that the institutions which have been created to us will be safe and sound when we as pilgrims in this path hand over the baton to our successors. And third, we must always remember the public trust doctrine, because we hold this institution in trust for the future. So if we apply these three principles, the precautionary principle, the principle of sustainable development, and the public trust doctrine, not just in the context of environmental litigation, but each day of our lives, we will ensure that our court remains vibrant despite climate change. For the court, there are no big or small cases. Every matter is important, because it is in the seemingly small and routine matters involving the grievances of citizens that issues of constitutional and jurisprudential importance emerge. In attending to such grievances, the court performs a plain constitutional duty, a plain constitutional obligation, and a plain constitutional function.